All right. Welcome, everybody, to Willow Legal Group's Coffee Chat. We are here today with Lindsay Parvis. Lindsay is an attorney with Joseph Greenwald and Lake. And for over 20 years, Lindsay has focused on helping clients navigate some of life's biggest challenges and changes, including divorce, custody, domestic violence, and financial matters like alimony, child support, property division. One of Lindsay's special skill sets is making really complex, complicated, maybe pretty emotional things pretty easy and manageable, bringing them down so that when you're dealing with this big thing in life, she really helps you navigate it in manageable pieces. Her services include representation and advocacy, family members, and parenting coordination and mediation. Whew, it's definitely been a day. Lindsay, thank you for joining us.
Thank you for having me. It's a real honor.
Yeah. Did I leave anything out of your biography that we should add in?
Well, interestingly, I think what we'll be talking about today is not divorce focused, though it can, separated families, you can see it play out is guardianship.
Yeah. Guardianship.
I do contested guardianship work, and then also prenuptial agreements for families who are coming together and starting their shared lives.
Yeah. So let's start with the guardianship piece. One of the things that we tell people all the time, like every single presentation when we talk about financial powers of attorney, is that doing the prep work now will save their family so much stress and heartbreak potentially later down the road. My least favorite phone call to get from any adult child is, I've got a problem with mom or dad and I don't have a power of attorney. So tell us a little bit about when does someone, how does a guardianship become contested?
Well, I've seen it become contested when family members are involved and not on the same page about who the decision maker or makers would be, right? So who the guardian or guardians would be. And the court can appoint co-guardians, but it's not, maybe I'll come back to that in a little more detail. I think when the court appoints co-guardians, this is not the same as like when the court appoints joint legal custody to parents who really don't get along well, right? But there are models for and tools that the court can use to try to help those parents get past impasse. It's a very, to my mind, a very different thing for co-guardians. And more often than not, the court is appointing one guardian is what I see to be making those decisions. Or when I'm talking about one guardian, really, it's one guardian of the person. You might have a separate one guardian of the property because they have different skill sets or their different needs, but still it's only one decision maker in each one of those realms. And so when back to your question, like, how am I seeing this become contested? It's when people aren't on the same page, usually people within the family. And it's not even so much that they have different ideas about the care that should be provided or what should happen ultimately with assets and how they should be managed. But those can factor in. More often than not, it's not that. It's the idea that someone would be left out, right? That the guardian would be the decision maker, that they would be running the whole show and everybody else would just be left out on the fringes. And it's that concern, I think, about being cut out that I see fueling it.
Share with us a little bit about what that contested guardianship process is like in a condensed version, if someone had to go through that, right? What is that what does the litigation look like? How does that work?
Yeah, so and I'll start with the end. The end is a trial before a judge, and a judge is deciding sometimes whether a guardian is needed or not, or if there's no dispute about whether a guardian is needed, who to appoint. And that trial might be a half day. It might be several days of trial.
Wow.
And to get to that point, before that, there's a period of time called discovery. It's a whole disclosure period where there's exchange of information between the parties who are fighting this out about their perspective on things, potential evidence they're going to use, potential witnesses they're going to rely upon. And so there's this whole disclosure period. And then before that, there's the filing, identifying that it's a contested case and getting it scheduled.
Yeah.
And so this process, a lot of times always the timing depends on the court's calendar, right? As to how soon you're going to get that trial. Sometimes you can get that ultimate trial fairly quickly because something opened up. But sometimes it's months and months down the road.
Yeah. And that makes it really hard for families. And just the parties to that, right, are the person who's seeking guardianship, right, and the person contesting, as well as the alleged disabled person, right? And that alleged disabled person is appointed an attorney to, advocate for their rights, and their point of view. Is that right?
That's right.
So there can be a lot of people involved, a lot of attorneys involved.
Right. And usually what I find, and I'd be interested in your experience because you all handle guardianships as well, just not the contested side, right? But like when guardianship is coming up, either I find it's part of estate planning and looking ahead. So it's not in a crisis period. Or guardianship is coming up because there's some sort of crisis that has already occurred or that really is about to kick off because, say, decision making's on hold and all of a sudden decisions are going to have to happen right away with a temporary guardian appointed right away without all that full disclosure and developing evidence and having a full trial, right? And having a judge decide it. Not that that's always an ideal outcome, but it's in this crisis period, right? And so coming into this contested process, it's usually very heightened emotions. Something has happened that has derailed the status quo of what has been going on before that might not have been ideal, but maybe was functional, or maybe a loved one. So the respondent, I dislike all of the terminology around the person for whom a guardian is going to be appointed, right? Respondent seems to be the most neutral, and I still find it very not humanizing, but or the respondents had some major health crisis or something else that just within that crisis, all of it kicks off. And why do I mention that? It's when people are in crisis, that is not their best decision making.
It's not their best side, right? When people are stressed, it's usually that fight or flight that kicks in, or freeze, right? And so you've got those personalities. And I think, we see the same thing, right? The most common call is going into a nursing facility, right? Or memory care without the right documentation. And those facilities want to make sure, right, there's someone there that can sign the documents or make the decisions. And so, without powers of attorney, they're looking for something that gives authority. And so we are big on preaching. Please get power of attorney. If you do nothing else, please, spend that money to get a financial power of attorney, and spend the money to work with an attorney to do that, because I don't know what your thoughts are on the state statutory form power of attorney. I think it's a great document, but I think it can be very confusing if you try to go at it on your own.
Yeah, absolutely. I was just looking at it today for a different reason that I won't comment on, but I was looking at it and I was like, that's a lot of information for anybody to take in. I mean, what is it now? I don't remember how many pages.
Yeah. And places to initial and not initial, and
what's the difference between this choice and this choice, and
yeah.
So it's good in thought. The intentions were good. The execution,
like so many things.
Yes.
Right. More is not necessarily better. Yeah. And totally. I mean, coming into this conversation, I was thinking about, what is the one gift that people can give their loved ones that will sort of provide that a clear path during crisis, right? And that power of attorney, healthcare directive, but doing those and doing them when you're not in a moment of crisis. And then you have a greater say. I mean, you've chosen who you've chosen for the reasons that you have in those moments. And then you can start having conversations with that person, that agent, that power of attorney, about this is what I want. Mm-hmm. So then you actually get to have more of a say in what you want at times when you're not able to communicate what it is you do want. And that is completely, this is an unfair statement, but in so many ways that's completely lost in the contested guardianship, right? The person for whom guardianship is sought does get their attorney, as Megan was saying, and they advocate for them. But if you've reached the point where you can't meaningfully communicate what it is you want, that attorney can only do so much. And I do some of that court-appointed representation, and I love representing my clients in that space to help them get from, where they are right now to a structure and a process that means functional decision-making is going to happen and their needs are going to get taken care of. But like in the contested part, there ends up being so little emphasis on that.
Yeah.
So, and I don't know that that's where people actually understand the decision-making ends up and what the process looks like if they don't do it themselves on the front end.
Yeah. And we try to talk a lot about that in all of our presentations and those types of things, right? That these documents allow you to stay in control. I think a lot of people hesitate, right, to put into place incapacity documents because they don't want to give up something. And talking to older adults and saying, hey, this actually lets you stay in control, right? You get to decide and get to have those conversations versus letting a judge who tries their best, given all the facts, but they're also humans, and it's what is presented to them, so they're not making decisions the same decisions that you would necessarily. And so trying to do that. And I think most of our clients say they want to make things as easy as possible for their family members, and this is one of the ways to do that.
Yeah. Right. I mean, yeah.
I've been talking with a lot, it seems like a lot lately, and I don't know your experience with this, but parents of adult children with special needs
Mm.
who are currently, the adult child doesn't have the capacity to create incapacity documents. The parent is getting older. Currently, obviously, they're caring for them, but what does that process look like once that parent passes away? Or if, the doctors decide all of a sudden, oh, I'm not going to let you make these decisions, even though I've been because technically they're adults. And so if they don't have, and so that, they've been asking me, when do I have to look for guardianship? And I don't really have a good answer for them. And I'm not until you need to is always what I say, because it's really, that's taking away the person's rights, obviously. But do you have much experience with like the adult child with special needs not having somebody to advocate for them? And how does that look?
Yes. Yeah.
It's that
Yeah.
losing, they're functional enough
Right.
that they do well with
Right.
the support, but when they lose
Right.
that support,
Yeah.
then what?
Right.
Right. So, in part, I also needed to slow down my brain a little bit because it was going in so many different directions to
Yeah.
talk about this.
Yeah.
Because this is the one area where, the idea I just talked about, like if there was one gift that adults could give their families,
Yeah.
except this is a gift that can't be given, right?
Correct.
Because these adult kids, so I'm going to still call them kids,
Yes.
don't have legal capacity to be signing powers of attorney or to be necessarily outside of a guardianship proceeding with their own court-appointed attorney to consent to guardianship, the way minors can. So interesting.
Right.
But okay, we'll just put a pin in that intellectual curiosity for another day. But what is the space? And so in the slowing down my brain part of it, the one thing I was thinking about is how, supported decision making is not something that I think is so well developed, right? There tends to, the law encourages and very much supports there should be less restrictive alternatives to guardianship whenever possible, and guardianship is the last resort. Right. Except what I find in practical terms is that kind of out and about in the world, the professionals who are looking for guidance, it's very much this on-off switch. Do you have guardianship or you don't have guardianship? We need a guardian. We don't have a guardian. So someone needs to be a guardian. So it's this very binary thing, whereas I think the law and guardianship advocates are, trying to develop that there is this whole world of assisted decision making for people who may not need a guardian, but who, with help through, say, guided, neutral, not agended, right, but like guided or structured decision making, that a person can have a say and be a participant in their decision making. So we got that whole part that's not really developed that I think of, are we really trying to exhaust our options? And does the guardianship process include really more than just asking the question, are there any less restrictive alternatives? They ask that and everybody says no, but there's no actual process to say, show us. Right? Like this guardianship case is going, let's do some test runs on what sort of guided decision-making could be, so that these kids could have an opportunity and their parents could really see what that could look like. Mm-hmm. So having talked about this whole utopia, we're going to set this utopia decision-making aside, and then what it looks like for these kids. Mm-hmm. And it's the kind of, not to only be binary, but I tend to see two scenarios. One is it's a parent or two parents who are looking for guardianship.
Mhm.
If it's two parents, they might be an intact couple, they might be together, or they might have parted ways. And so they are separated parents who are disagreeing and in contested guardianship litigation around who should be the guardian. Or for adults, to a question you all were asking about, adult kids who can't make their own decisions, but their parent who maybe up until now it's functioned with, say, a power of attorney and that parent making decisions, or somehow it's just managed to function without a formal legal document. And then that parent is no longer a decision maker. That parent has passed away, or they are receiving services themselves and no longer able to be making decisions and taking, implementing the decisions they're making.
Right.
So, in those two different scenarios, the court is left with, in the contested context, which parent? Is there a parent and who? And then in the other, if there is no one else, then we have the Department of Social Services and Department of Aging who will step in and do that. In some respects, it's almost simpler when the Department of Social Services and Aging steps in to make the decisions, because there's not a whole lot to fight about, right? Like, here's our decision maker and here we go. It's the family's
Scenario.
It's the family scenario, especially when they're not on the same page. So sorry, that was a long meandering answer. But
no, it's a big one though, because there is a big, and even with the supported decision making, the law says there doesn't have to be a form, but if there is a form, it needs to have all these things. And I've been trying to come up with a form that has all of these specificity, but if you can't understand the specificity, how can you agree to it? So it's like this whole thing where I was just curious your experience, because I'm struggling with that right now.
Yeah, and I think I think we're seeing more of it, right? As you have a generation in which there are more kind of mental instabilities, right? You've got more people, right? You've got whose parents are passing. They've been taking care of their child for, forever, and they're family members that can step in and that will step in, but it's a whole new question and process. And how do you transfer, even transferring things like Social Security disability from one parent to the other when one parent has passed is like a whole thing, right? And it can be very traumatic on the adult child even, right? Having to go in and be reevaluated, all for good reasons, but just it's a gap, right? That I think we're going to see more of as we have more adults who, can kind of grown up, integrated with their families, and it's worked out really well. But what's that support system, right? Some mechanisms for that support system. Support system might be there, but trying to kind of make sure it goes through with the least stress.
Yeah. Well, right. And to your point, like, the appointment of a guardian is, like, in a certain sense, step one. I mean, it's a new beginning, right? Because you have whatever process there was to get you to the point of a guardian's appointed. Whew, that's done. Except the guardian has to do all their work, right? And then they've got to implement decisions. And, this is, it's not a light switch, just to use an analogy that, like, I used before. It's not like, ooh, guardian's appointed, light switch is on, and then all the services magically happen.
Right.
It is so much work.
Yeah.
So much work.
So, well, this has been awesome. And Lindsay, we're going to have you on again, and we can talk about prenups and postnups and all the love that goes into that planning, right? As we talk about planning for the unknown, right? And that's a big big piece of it. So we'll do another coffee chat down the road to talk about those pieces. What's the one thing that you wish more people knew and understood when it comes to guardianship?
Oh, the one thing, and Megan, I'm going to sound like you, but I think it's so true. And really both of you, right? That doing the planning in advance means you have a say and you're shaping and creating your future. And that is such a gift to your family. Like, please do that, because ending up in contested guardianship litigation may be very satisfying work for this person, because I find it interesting in trying to help families and the legal process, and how do we get help for, this person in need of a guardian. But it's not a very positive, affirming space for families and the people who have to go on to make the decisions and communicate with one another and remain family afterwards. So, yeah.
See everyone out there.
It's not just
us. It says, please get your documents in place. All right. What is the one item you can't live without in your day-to-day life?
Oh, though it has taken different forms, and I am in an experimentation period right now, sippy, my water bottle. Cannot live without it. It goes everywhere with me. I spend more time with sippy than I do with my spouse, and we act. But water is the single, consistently healthy thing I've done for myself. Everyone can do it. I support everyone having a sippy.
Excellent.
Love it.
I mean, we both have ours right here. So,
all right. Well, Lindsay, this was wonderful. Thank you for joining us.
Thank you. Thank you for having me. I love the conversation. This flew by, maybe more for me than it did for you, but it was great.
But yeah, we'll definitely have you on again. So
talk. Yeah. All right.